My name is Michael Beurskens. I'm from University of Passau, and I'll be talking about copyright in AI created works, specifically the question whether AI is used as a mere tool or if it's used as a measure to pirate foreign works, or if the AI itself as a creator actually deriving humans from any rights in their products. So let's start with the initial question. Why is this question even relevant at all? Initially, this was all about research projects. And if you take a look at Dolly and whatever you want, they were initially projects just done for research, and you had some internal uses, and then you could actually apply for access. And after some time, they made you available, I don't know, 3 or 4 pictures generators per day, and you had very little danger of copyright infringement. Nowadays, those tools become increasingly common. And one reason for that is that commercial participants integrate their technology into standard desktop software. I have the example of Microsoft. Microsoft has a tool in PowerPoint which is called Designer, which actually applies a design to your slides. You'd write a text and they make it look fancy. They currently don't generate pictures, but they have an updated version which they have even separated from PowerPoint to create logos and business cards and invitations, which will be run in your browser and which will make use of the DALL-E image creation network. So you can enter, as you can see in the bottom picture, confetti falling on stage with blue lightning, and it will generate pictures which have this motive. It uses the image database which was accessed by DALL-E, and the question is, of course, who owns those pictures, who is able to license them, and is there any issue involved which might prevent your use of those pictures? And when a product becomes mass market relevant, of course, the legal issues become far more interesting than for a mere research project. Furthermore, we have an issue with AI-generated content, not only in the area of pictures and movies, but it's also in any kind of legally protected work. Again, Microsoft is using artificial intelligence in software development. If you use Visual Studio, or if you use the integrated web-based Visual Studio integrated in GitHub, they give you code suggestions. So they give you suggestions what could be done to solve your current issues. They guess what you want to do by your variable names, by your comments, and by the formal structure of your code. And they take their suggestions from an AI, which is in itself based on all the code published on GitHub. GitHub is a public repository where people may publish their code, and they have their source code available for millions of projects. And the AI often generates codes which is very much like one of those projects, simply because there is not that much code base for a specific computer language. So often you can see this looks a lot like my code, and why is Microsoft giving my computer code away as a suggestion for other developers? It's essentially the same issue you have with the picture generators, with the only difference that this is text and a specific text in itself, and so it's a lot more easier to detect who wrote it. So if we have a legal issue with these, the question is, how can we regulate it? And a legislator has 3 mere solutions to any issue. First of all, he may prohibit it in itself. So you could have prohibitions for artificial intelligence. And if you take a look at the proposed AI Act of the European Union, you have certain areas where there is a prohibition on the use of AI, and that's it. So you have the same thing as you would have with military weapons. Nobody can buy them and sell them without a specific legal permit. You can have a lower level, you can have some kind of state supervision of the production. This is what I call the driver license model. You can actually drive a car without a driver license, but getting a driver license is far easier than getting a permit to trade in weapons. And of course, you have the same thing with the cars themselves. They have to be approved to be fit for use in public streets. So you have a review procedure and you have a licensing process where people know who are the participants. And of course, the lowest level of regulation is what we usually have in copyright. You have a mere warning telling you, well, be careful, don't do that. And then you have rights of the infringed person, which can be made use of ex post, especially compensation. If you take a look at fair use, this is what usually happens in copyright when something is very widespread and in the public interest. The copyright owner will only be compensated and he won't actually get a right to prevent the fair use. So if you have those three means of regulating, of course you can apply them to any phase of the generation of the artificial intelligence content. You can apply them in the initial content gathering phase, what I call the input phase. You can say, well, it's prohibited to crawl websites. You can actually prohibit gathering of data. Or you could actually provide for compensation even at this stage. So the mere crawling of the internet would be required to be compensated. You would have to pay to look up information. Of course, it can be seen, this would be very, very hindering to search engines, to content sharing, to everything you do on the web. So it's very unlikely that this approach would prevail. So another approach would be to regulate the second phase, to say, well, you may crawl the web and gather the data, but once you process it and create something from it, that's a bad thing, and you could have a prohibition or right to compensation. And finally, you could regulate the result itself and say, well, you can actually process the data, but once you make use of the results, you have to pay someone or it may be prohibited. So you could only do internal research, but never actually sell it to someone else. Should we give any copyright at all? Or should this be a work in the public domain? And the answer is easy if the AI is really a mere tool and there is at least a minimum of creativity in 1 or 2 or 3 humans involved. Then it's easy and we can assign the copyright to those humans. However, the more independent an AI gets, the less it's dependent on input from a certain person, the more it is random, like nature, like an animal painting a picture, or like a flesh cutting a tree in half, the more we get to a point where we can say there is no copyright at all, it's a work in the public domain. And this is a point which is mainly accepted. If something is generated through AI and there is no human intervention, no significant human intervention, it cannot be copyrighted. This was actually expressed by the US Copyright Office, and we have a similar paper by the EU Commission, who also says, well, if you have works created by an AI where there is not a minimum amount of human creativity involved, nobody gets a copyright claim to that, and the work is initially in the public domain. This causes an issue, simply because if you have a human who creates a work, he may infringe on copyright and he may be sued. However, if you only have an AI who will never get a right to the copyrighted works, who will be the infringer? And indeed, it's all about the human behind the machine, even if he gets no copyright. So what we do is we take the artificial intelligence and look at its results, and then we attribute those results to the human user, but only with regards to infringement and not with regards to the creation process, to the ownership of the copyright. There is a huge issue with regards to the person who should get the copyright claim, if any. And this is an economic issue because you have to look at who actually has to do any effort. And if you take a look at the input the AI uses, it becomes really muddy. Initially, what an AI does is it's trained. And to train, you gather data from multiple sources, and it has to have a lot of data to produce actually creative or seemingly creative results. And usually, unless you use historic art, there is a copyright claim in all those new data. So you have pictures, photos taken by somebody, and usually there is some kind of copyright claim involved. And of course, those people would have a right to compensation. Secondly, the AI itself costs money to create, and the cost to develop the AI tools, to develop the algorithms, to say, well, we want to ignore this data and that data, this costs a lot of money. And of course, you have to pay for that. The developers want to be paid, they don't do it just for fun. Then if you take a further look, what happens is you take all the data and use it to train the neural network. And this is what costs real money, simply because you have to have a lot of calculation power, processing power, you have to have high-speed graphic cards and so on, and everything is used to actually create those results. Well, there might not be creativity involved, but at least it's a lot of money involved. Then you have the user requesting result, and usually he just types a few words in the computer, I want a car with a pink mushroom on top of it. And this is all he does, and this is his creative idea. Of course, the more creative your short text gets, the more likely we are to say, well, this is copyrightable. However, what we really want is the result. And of course, generating a result might also cost money, simply because you have to run the request through the neural network and generate some suggestions. Why do I look at those steps so intensively? Simply because I want to tell you it's pretty hard who should own the result which you actually get in the end. Should that result be owned by the person who just types in something? Should it be owned by the developers who don't even know what will happen? Should it be owned by somebody who is included in the training data, who we can't even identify in a huge mass of information? Or should it be assigned to somebody who has to pay for all the hardware, for all the energy used, for all the other costs? We don't know, and so there is no easy solution to that issue. It's just the problem that we will usually get a shared copyright between multiple parties, which is pretty hard to enforce and make use of. Well, what I'm talking about today is nothing new. You have a paper, for example, from the United Kingdom Copyright Office, who did a consultation and said, well, it's a huge issue and we have to work on it. We also had papers as early as 2017 where the World Intellectual Property Organization tried to find a solution to this issue. And of course, the International Association for the Protection of the Intellectual Property, the IP, well, had a congress in 2019 where they had a half day to discuss all those issues, and where they had presentations on the handling of those issues in different countries. And funnily enough, there is no real solution. However, there is a universal agreement that there is no copyright assigned to machines. So it can only be about humans. The question is only who in the human sphere. Well, that's it about the issues. Now let's look at a few specifically legal solutions. You might have heard about Bruce Willis selling rights to his AI twin to appear in new movies, which later was denied and said, well, this is fake news. He only allowed it to use for one Russian commercial. Without the question whether he did this or not, the question is, does he have a right to prevent others from using his appearance in movies, advertisements, and so on? And of course, there is the general idea that you have a moral right to be identified as a performer. And this applies to the original performance as well as any outtakes, remixes, and whatever. So anything you have which would be done simply by manually editing the movies. Furthermore, you have a right to prohibit any modification that would be prejudicial to your reputation. And of course, the idea is that you can prevent your appearance to be used in something like porn movies or used to actually threaten people. So you have a right to protect your appearance. This right is universally accepted. However, the Beijing Treaty on Audiovisual Performances has not yet been universally transformed. I said before that porn is a huge issue. This was what was discussed in the deepfake debate very early on. And of course, there have been people who said, well, let's make money out of it by selling porn with your face on it or the face of someone you know. As you know, this is a huge moral right issue. The porn actors might actually agree to have their body used in those videos. However, the people whose head is used will usually not agree upon it. And so we can be pretty sure that this would be something which would be prohibited by the persons involved. However, it's currently a question of detecting people using your picture in porn to actually sue them. It's also pretty easy to regulate. In California, you have laws preventing your pictures to be used in political statements. You know, like politicians used in videos to show that they actually do some really right-wing or dangerous or illegal stuff. Or, of course, pornographic content. So it's easy to prohibit that use by public law, and it's not really a copyright issue or moral rights issue. It's more an issue of, well, public welfare, of protection of the integrity of the society. So that is an easy question. However, the tough question appears if you actually create or use pictures of persons who do not exist. The idea of a remix person. Is there anyone involved who could have a moral right claim to that picture? Because this is not a really existing human. It's just something which was remixed by an AI based on multiple pictures. So once you have unidentifiable pictures, it's pretty hard to claim a moral right based on the Beijing Treaty or on any other right, simply because nobody can see your picture. And if nobody knows it's you, you have no need to be identified, and it's probably not a modification which may be prejudicial to your reputation. So where does this lead us? Well, once you use the original picture or original motion in a video to create a new work, you can actually say, well, we prohibit this based on moral rights. However, once you create something really new, which is not even looking like the original, this is not a moral right issue, and you wouldn't have any claim to prohibit it or even for compensation based on moral rights. So the other question is, of course, can you do something about compensation? Even if you are not identifiable and it's not a work which is pretty prejudicial to you, you might say, well, but it inflicts on my means to make money. I work simply because I'm a voice actor or I'm an actor, and I get money for my appearance in movies. And if I get replaced by something AI generated, I don't get any money. And so this is actually not a moral question. It's simply a question of getting money. And indeed, if you take a look at current campaigns, both in the US and in the UK, people are campaigning for protection against AI, especially actors and especially voice actors, which are really often used in computer games, for telephone platforms, for navigational systems, and so on, because currently you have someone in the recording studio who gets paid, and in the future you might only have an AI who generates generates speech based on typed text, and so you would actually not make any use of those voice actors. So you have the voice actor associations actually really enforcing their claims, and they hope for regulation by the respective regulators. So they want to see some new laws. And indeed, if you take a look at current tools, you have Sonantic, which was recently acquired by Spotify, and that tool is really, really easy to use. You can just type in a text and say, well, who is the speaker and what emotion does that person have, and they generate the spoken text from what you typed, which is really great if you're in computer game development, because you have a script which might change and change and change, and you just want to see, well, how would this look to a player if it's spoken? And you can't always hire a voice actor for every revision, and so you just create a draft based on computer generated speech. And it's interestingly such a good quality that you could actually replace some low budget games using those computer generated speech texts. And so there is indeed reason to be worried that a voice actor might not be needed, at least not for every project which currently makes use of him. And of course, this is a core issue if you take a look at copyright, if you take a look at creative works. You have all those artists painting pictures and somebody uses their style to create a new picture. We have this issue currently debated with fantasy and sci-fi pictures, which are often uploaded to a public platform, which is sort of like a gallery where people can see what artists do. And then those artists actually see something which looks really, really, really like their style, like their type of picture on AI-generated platforms. And the reason for that is because when they have a very unique style, the AI actually gets a lot of data of that style and is able to imitate it very good. And so you have an adaptation or arrangement which would usually be attributed to the person who created the original work. It's the same thing you would do if you had someone just copying or imitating the style of a famous painter in his own office using a brush. However, again, there is no issue if you create a new work inspired by someone else. So the line is pretty hard. Is this just a mere inspiration, or is this just an imitation or alteration of the original? And we have really, really tough issues if you take a look at some of the AI generated content, where it's a combination of a number or a huge number of artists, and you don't have a specific artist who can be the one who can claim that it's an alteration of his or her work. The idea is, well, of course, the providers of such platforms currently say, we don't hurt your business, we actually improve it. Because if you have your voice on that platform, people will create their drafts using your voice, and later on will hire you to create the real recording. The CEO of the aforementioned software company says voice actors will always be needed. AI voices will never replace actors because only actors sound really alive. Furthermore, they say, well, we give you a share of the money we get. They also say, well, we are using something which sounds very much like your original voice. This all works simply because the voice is specifically attributable to a one person. Unlike the AI cases with the pictures, where you have a combination of multiple original authors, you have a specific one who can claim this is a derivative of my original. So in theory, this sounds great. You give everybody compensation whose original work or original picture is used in the derivative product. However, this leads to a number of issues. First of all, the question is, can we really do with licensing? And the problem is, if you have an AI crawling the web, there's pretty little you can do to prevent it from gathering your picture, and there's pretty little you can do from using that picture to create something new. Furthermore, if you just license your work, you run into the original moral rights issue that it might be used for something you wouldn't want to appear on. We talked about porn, which might be something you don't want to be a porn star just because you have a good looking face. The same thing applies, of course, to advertisement. If you use the voice of a famous actor or his lookalike to promote a product, he might have licensed his appearance or his voice to some AI provider, but do we really want to have famous people saying things they don't agree upon? As you saw in California, you have laws specifically dealing with political issues and porn issues. However, it might also be unfair advertisement if someone who is a vegetarian is used to promote Big Mac burgers for McDonald's or Whoppers for Burger King. So this whole thing might lead to an unfair competition claim against both the provider of the AI tool as well as the person who licensed his voice, simply because it's a mere lie. That person does not stand for that product. So licensing in itself is not the perfect solution. For one thing, it's really tough to get the agreement of everybody whose photo is on the internet, simply because you can't know who the possible claimants were. And secondly, because there might be a right of the public to know whether the person specifically allowed his use in the thing, or if he just generally allowed use of his lookalike or voice-alike in an AI tool. So where does this leave us? Well, as I said before, we can actually regulate any step of the creation process. We could prohibit the crawling scraping. We could also ask for compensation for use of content in that phase. Furthermore, we could regulate the machine analysis, data analysis phase. Again, we could also ask for compensation. We could also provide the generation of the content. And finally, we could regulate the use. If you take a look at the first phase, there is a really huge tendency worldwide to allow crawling and scraping. And you have the EU directive on the digital single market copyright, who expressly says there is a right to data mine, and that right allows for reproduction and extraction of any lawfully accessible works and other protected subject matter for the specific purpose. However, the EU has an exception which says you can prevent being crawled if you reserve that right. However, you have to use a machine-readable means in the case of content made publicly available online. So you would have to have some kind of metadata or robots.txt which actually prevents your image or your text from being accessed in crawling. This is not a Europe-only thing. The second idea, of course, would be just let it be scraped, let it be used, and clean up after the fact. And as you might have read, there is the Clearview AI. The Clearview AI is used for face recognition. So they know who you are simply by gathering your face. And it's used by intelligence agencies to detect where you appear on public cameras and so on. In the EU, this was considered a breach of the Privacy Directive. However, the problem is that you have to clean up the database in the aftermath. And this is really tough. Once you have the data, you have to identify the subject in all your database, and you have to actually ensure that the person wanting to be deleted is the person who actually is depicted on the picture, which is pretty tough in an online process. So you have to identify that person by some kind of photo ID and so on. So cleaning up after the fact is pretty tough. It becomes even harder if you take a look at more complex neural networks where the original work isn't even stored. It's just some representation of elements used in certain works which may be merged and synergized, so you don't have a specific work in that database, you only had it in the original training data. So cutting out that information in the resulting network becomes almost impossible. So what is the possible alternative? Of course, you could have a compensation of any person whose original content was used. And the idea is that the neural networks used for creating images would actually have to determine who has had an impact on the resulting work. So if you have 1,000 people whose work influenced the resulting image in a specific case, any of those 1,000 people would have a claim to compensation. We currently have pages where you can check whether your image was used at all in a training data set, in one of those publicly used training data sets, because most of the image generators use identical data sets. And of course, there is an increasing effort to create watermarking, which makes original works identifiable in the resulting product. So the idea is that you would have a mark in every kind of work which say, well, this is where the thing starts, and this would carry over through the whole process where the data is trained and used, and you would have the result. So the idea is you can say this resulting picture includes elements by A, B, C, and you would have, I don't know, 1,000 people whose original work influenced it, and anybody would get a small kind of compensation. This is not something you can regulate privately, simply because you would have to have license contract with all those people. So this is not an issue which needs regulation. The compensation issue can only be resolved by law, in my opinion, simply because you would have to have a statutory license and grant everybody involved money. Thank you for your attention, and I am open to any kind of question. Thank you very much.